I think we'll go with one final question for the panel. Regarding expert fees, I know we talked earlier about having prior authorities, etc., but we do get a lot of questions along the lines of what does the legal aid agency do if, when a provider sends in an estimate for the expert, there is then further work that's required, whether it be an additional report, a top-up report, or attendance at court to give evidence. Do they need to go back, get more prior authority? Do they need, or can it be assessed when it comes to the final submission?
I don't mind taking that if you want, Anthony, because obviously I see that all the time.
Yes, by all means.
Please, John, thank you.
Generally, what you get with prior authority, say if it's been granted for the first initial report, say if it's over the codified rate, then say if they've been told to do court, instructed to do court attendance or addendum report, anything like that, we would allow the prior authority rate that's been granted for the previous. However, I would advise them to submit further prior authority if the addendum report or court preparation was excessive, because then that would have to be considered. Obviously, we can assess it on the final case plan, but regarding expert fees, we generally stick to the codified rates, the prior authority rates, and the times allowed. I mean, we do have the discretion as a case manager to assess it, which is what is above, but we generally would stick to those guidelines.
I think it's worth possibly saying, just to back that up, John, that we need to understand why the estimate was short. We need to understand the background to why that wasn't, why the estimate sort of was not as accurate as it intended to be. We need to understand whether there was any change in situation once the expert became involved, an instruction to understand the background to that. I suppose the safest thing to say is, if you've got time and it's possible, amend the prior authority. I think that's probably the safest thing to say. But there will be times, of course, once the instruction's gone in, of course, to the expert, it's a bit late at that point because the instruction's already there. We will certainly be reasonable in the way that we understand the information. We'll interpret the information that comes from you to support at the end, as John has said.
I think also we'd like to add, from a communication channel perspective, it's not only council clerks that you need to communicate with, but all your experts as well. Because if it's something that we're dealing with from an assessment perspective, we're going to be asking those questions, and it will delay final agreement if we're short of information from an expert's perspective, just as it would from anything else.
I think it's also worth saying probably that, if you've got an initial prior authority, because the rates used are beyond the codified rates, if we're accepting the additional work of the expert, we will be accepting it on the basis of the hourly rates that have been allowed under the prior authority.
Absolutely.
As part and parcel. I think for clarification, we'd say that as well. Rebecca, have you got any particular experience from that you would come in on us on that, or?
Yes, yeah, I think we still see experts, even though they're instructed under codified rates, we'll still see experts sending their fee notes that are above that level. And I think the solicitors that have sort of got a procedure in place where whenever an expert's fee is received, to stop at that point, look at the rates, make sure it's correct. They're the ones that are then able to be billed quicker. Again, it all goes back to front loading because they've already gone back to the expert to seek an amended fee note, and then we've got everything that we need at final billing stage, rather than leaving it until the end, by which point we tend to find that experts are a little bit more reluctant to change their fees, and it takes a little bit more time to get those amended fee notes out of them. So I think if you can put a practice in place where it's checked at the point it's received, you're just helping yourself out there.
Thank you. No more questions. I think we'll pass you back to Mr. Marshall, who's going to go through some hints and tips.
Thank you very much, John. Thank you very much, everyone, for your input. Yeah, just to briefly finish, I'm going to go through some hints and tips. I've got 10 of them. What we generally find is that more of the issues we found when assessing, especially the final case plan. Firstly, council can only claim CCFS rates when there'll be more than 10 main hearing days. This is for one council and two council. Underruns and overruns do count towards main hearing days. Number two, regarding advocates meetings, for two council, as previously discussed during the presentation, each party can have two attended advocates meetings before the final hearing, and then two attended advocates meetings before the final hearing. Obviously, this has to be evidenced with attendance notes and endorsed brief back sheets. For one council, it's slightly different. Like we said, it's as many advocates meetings as it has been court ordered in advance, whereas solicitors don't have to provide evidence unless they've only attended it by themselves. Council have attended, and if it's at FAS, we don't need evidence. If it's at events or CCFS rate, sorry, we do need evidence. And number three, when dealing with the final case plan, it's obviously very handy for the case manager like myself to, when you upload it in clumps, for example, and give a brief description of the document. For example, upload it such as the final case plan, court orders, council fee notes, claim fives if council or FJF, invoices, endorsed brief back sheets, attendance notes, and if possible, it makes our job a lot easier if you highlight the court orders, the relevant sections of it, like for the drug, DNA, the transcription cost, advocacy meetings for single counsel, and the main hearing days. It also helps billing as well. This whole process, so we don't miss anything, so we can get your costs agreed as quickly as possible and everyone gets paid, which, like I said, at the end of the day, that's the main reason why we're here. Number four, we have issues sometimes with interim case plans. Sometimes solicitors will provide interim case plans that are under the current cost limit or under the 60,000 or 32.5. We don't need that because, as I said, the costs are already there available for you. And also don't supply supporting documents for interim case plans because we don't need, unless we specifically ask for them, we don't need them. This will all be assessed, like I said, in the final case plan. On my fifth point, obviously we have certain cases that solicitors will still be on hourly rates and council will be on CCFS, obviously standard case plan. And this will take longer than a traditional CCFS case plan because obviously a CCFS case plan is fixed fee, so it's generally a bit easier. Obviously, with standard case plans, it's hourly rates. So where we find ourselves it can take a lot of time negotiating certain points. So yeah, as I said, CCFS is generally a simpler process and a simpler scheme to use. What we found, because we do on high cost, we do a case decision log, so we log what areas are the main issues, and this comes to my sixth point, where we see a lot of reasons why the case plans are rejected is because the final FAS documents are missing, or the final case plan hasn't been completed properly, like the cost summary page, or even signed at the bottom, or the list of events doesn't match the cost summary page. So it's just as simple as, adding up what's in the list of events to the cost summary page. And obviously, sometimes you get cases that have appeal work, which we discussed before. And we obviously need, the supporting documents for the appeal work, council fee notes, expert invoices. Generally, the case plan is filled out sufficient enough where we can assess the actual hours that the solicitor claim. But in certain instances, we may ask for claim one, but that doesn't happen that often. My seventh point, it's a bit of a clerical one, this one, because it's a bit of a simple one. A lot of times cases don't get agreed straight away. It's because we don't have the signed contract or the signed CAFs, which is obviously, it's a simple thing to get right. And we'll, if we get them as soon as we possibly can. I know obviously with CAFs, they sometimes are delayed, but if that we do see that as a big delay towards costs getting agreed finally, and that can obviously easily be rectified. On my eighth point, we do see it on certain occasions where solicitors try and claim for conferences, which generally isn't allowed. The only time they can claim for conferences if they were an advocate and not acting as the litigator. On my ninth point, we've discussed this about reading days. Generally, they are not claimable and do not count towards the main hearing days unless the judge has ordered this as a sitting day and you've attended court, then it will, and you can't claim an event for it. My final point is to go over written submissions. Obviously, this is quite different on one council, on two council. On one council, it's slightly simpler. As long as it's been court ordered and the party that created them, they can claim a full event for them. With two counsel, this is slightly more complicated. It can only be part of a singular main hearing that's been in excess of 10 consecutive days. It has to be after the 10th day. It has to be originally listed as a hearing day and then set aside by the judge for written submissions, where the party that created them will claim a full event, and then the two other parties will claim an underrun. And you can only claim one full event for written submissions per main hearing, or sorry, per fact find hearing, per final hearing. So yeah, they're just the 10 main points that I'd like with my hints and tips to go over. We normally see as major issues when it comes to agreeing the case plan. And that concludes our high cost webinar. I'd like to thank everyone for joining us. I'd like to thank the presenters who've took time out of their day, which has been very beneficial for both sides, for us at the LAA, agreeing your costs and obviously getting your costs agreed first time. I hope this has made a clearer understanding of the CCFS process and the case plan process. Regarding our guidance and information, this can be found on the gov.uk website, and if you go into the LAA and type in high cost cases, you'll find all of the information, info packs, the checklists, and all of the forms of guidance that are very helpful when doing high cost work. Regarding the webinar, there's a published Q&A document from our live webinar sessions, and this is on the Legal Aid Agency's training website. So if you have any time, could you please fill that in? Thank you, everyone.